Sir, good morning, sir. Sir, am I audible, sir?
Yes.
Fine, sir. Thank you, sir. You're also audible, visible, sir. Thank you.
Thank you. Thank you. I just want to mention that.
Sure, sir.
Yes. May I mention a matter, Your Lordship directed to be listed today, not listed.
After notice matter.
Lord?
After notice matter.
After notice matter.
Well, after the reopening, it will come up.
Lord, would Your Lordship direct the first day after opening, because
Just see Punit.
it's a short matter, and Your Lordship
I'll
has
just tell-
kindly,
I'll tell.
yes, you had kindly directed it, which is why I mentioned.
Yes, yes.
Okay.
May I have your lordship's leave to mention minutes?
Yes, Mr. Chairman.
Sent an email. The matter is listed on the 5th of November. My
Yes.
only request is, now that it's listed, it should not be deleted on 5th of November.
NTD, not to DD.
Lord,
Thank
may I
you.
mention, Your Lordship were yesterday pleased to accommodate one disabled candidate who had secured 113 mark for an interview. Lord, I have a candidate who secured 111 mark. The only difference is he is in OBC category. He otherwise fulfills the same criteria, my Lord. If it can be accommodated.
This board gets over, my two brothers are going to take the board. It will be before them at the bottom of the board.
I'm most grateful. Lord.
Produce the paper.
I'll miss.
Lord, may I mention a matter for withdrawal? But there is an appeal which we had filed. SLP, my lord, leave was granted, we wish to withdraw it.
The registrar,
Yes.
Justice Pankaj Mittal's chamber board is not sitting today.
Yes, my
I have
lord.
reassigned it to another chamber, so you can just
We
mention.
had actually,
Mr.
filed
Mehta, it will be
Yes,
placed
we
before
can-
another chamber judge. You will get an opportunity to apply for withdrawal notification.
Lord, we had actually circulated.
What is the appeal against?
Lord, appeal is against an order, Lord, regarding the appointment of a panchayat. So,
Yes.
Lord, what has happened is we have come in appeal and there is a stay, and we want to withdraw this so that we can go ahead and have
Then-
elections.
We can call for the papers. We'll take it on board and withdraw it.
I filed
Consulted
it.
by Mr. Shyam Mehta, Learned Senior Counsel, with so and so, to withdraw, unconditional withdrawal. Okay? We'll do it now.
Will not please mention this matter. This is pertaining to a tender whereby Milord's pursuant to the judgment of the Honorable High Court, Milord's the state has cancelled my tender despite Milord's the agreement having been executed in my favor. Milord's, if it's re-tendered in the next week, Milord's, it will become infructuous. Milord's, may I please request this to be taken up today, Milord's? Milord's, the entire relief would become infructuous.
Tender
If
matter.
it's Milord's, the entire agreement has been granted in my favor. Despite that, Milord's, the operational agreement has been executed in my favor. Despite that, Milord's, in pursuance to the judgment of the Honorable High Court, Milord's, the state has Milord's cancelled my
The
LOA.
court has cancelled your.
Please, Milord's, my
What the
LOA.
contract?
Please, Milord's.
When is the implement order passed?
Lords, 17th of September. But Lords, I received
This
the
is not
cancellation
fair.
it's only day before. Lords, I've received the cancellation.
17th of September, the order was passed. You must, you waited for all this while, now wait for a week. Yes.
Right.
Lord, may I mention a fresh matter, my lord? I have given the email, my lord. But this is against the. But my application for stay of conviction has been rejected, my lord. I am desirous of. Grateful.
He told me before I came to court, I was assigned it to Justice Surya because 29th is the last day for filing a nomination for the MLA's election. Sure. You can at least have a hearing today. I've given it to Justice Surya Khan. It'll be at the bottom of the board.
Grateful.
Sorry. 85 days.
Lord, I'm in this matter. Lord,
85 days delay.
Lord,
So
only reason is,
delay, keep the question of law open.
Lord, the only request is, if your lordship, Lord, one, same as a C, other years are pending. And the stake,
if he succeeds,
and the stake, and Lord, the stake involved in this case is 193 crores.
How much is it in this case?
193 crores. Lordship, I issue notice on delay also, Lord, I don't mind, but please consider.
We'll say notice on delay and on the SLP.
Please.
I don't know. It was the respondent. The petitioner floated tender lords for construction of canal
This is a
93.
concurrent finding.
Lords,
Apart
after
from the 73-day delay,
That-
this is a concurrent finding.
Lords, unfortunately, my lord,
You know, that order on limitation operates as an interim award. You should have challenged that.
lords, we have challenged along with the final order, my lords.
You can't wait for the final order. It's an interim award.
Lords, but they approached the arbitrator after 22 years, my lords.
That's all right, but you should have taken challenge of the award dismissed first. Item 3.
Grateful. Lords, there is a delay in refiling. And
Yes, we'll take under this.
I'm grateful.
Yeah, please, please. Let's-
So one of my judgments of.
Who's it?
Lord, I appeal for the
We are being led by Mr.
Respondent Gas Authority.
May I please, Malaj? So far as the C form acceptability is not an issue, Malaj. Page 33, para
Because
35.
admittedly, the duty was paid, the VAT was paid, and admittedly it was not payable.
Yeah, so but on the C form is not an issue, Malaj.
Yes.
Its only issue is the principle of unjust enrichment. Whosoever is a claimant should satisfy that. And in this case, it is an admitted position.
That will not interfere with you. Thank
No,
you.
the only one thing which I want to point out is because this judgment is based on a reliance on the judgment of this honorable court, where there was a factual finding that the unjust enrichment not there. I only don't want to be in a situation that I don't raise it today and tomorrow they say that all right, the Supreme Court judgment has been followed, where factually this was a position. In this case, in their writ petition at page 68, it's an admitted position that they themselves paid 14% and they received 14%.
On the case for our interference, yes.
Well, all I'm saying is that the
No,
let's
our case for interfering.
keep your place.
the only
We must follow now some sense of justice to assessees as well. You know, and merely this.
I'm not suggesting for a minute, Malaz. And my lords
I
have laid
cannot get a refund.
my lords have laid down, Malaz, the person who has suffered the tax should get tax.
Yeah.
That's all I'm saying.
But
I suffered the tax.
yeah, they have suffered. They have paid the
I
tax.
suffered the
That's
tax,
all.
Lord.
It's a matter of in Mafatlal, my lord said it's a matter of inquiry that should be done.
We'll close it here.
Wait.
Thank you. Item 4 is TOLA. It will be governed by our TOLA orders. So that there's a common order which we have passed in the entire group.
I'm sorry, there's a refiling delay of
Refiling delay.
It's
So
the
we
same
passed
order,
the
my
same
lords.
order.
In all these matters.
All these matters, right? You're appearing in all these matters.
Yes, my lords. 4, 6, 11, 12, and the connected matters, which are 14, I think.
14, 21, 24, 25, and 27.
Third,
All matters will be governed by the TOLA order.
yes.
All right? Item 5.
Please, your lordships. Lordship, I am the victim of this.
Delay of 181 days.
Lordship, due to the financial constraints and
Sorry.
certain medical issues were there also.
They have relied on the Pardiwala's judgment in Selir LLO versus Bafna.
The facts over there, your lordships, and the facts of mine are totally different, your lordship. I can satisfy your lordship by
Point is,
annexing.
you have to open the door ajar. You have to first come within limitation. There's a delay of 6 months delay.
Yeah, but your lordship, he was having financial issues. He's a very poor litigant. Somehow he managed to come. There were financial crunch also. And
Item 8.
lordship may give me the liberty to at least approach the DRT at least.
Whatever you have, you have. Yes, item 8.
Item 8. Lord, I have.
Oh, item 7.
Item 7, my lords, is Ganpati Dealcom. What my lords had done is, in right of the order in the review petition, my lords had issued notice.
Yes.
Because what has to happen is that it has to go back to the High Court, because it's been dismissed only on the basis of Ganpati Dealcom.
Oh, I see. Have you issued notice in this matter?
My lord have issued notice in a similar matter.
So we'll issue notice and tag it with that.
There's also a delay, my lords, 204 days.
We'll issue notice on the delay and tag it.
Obliged.
But here the issue of my lord, JP Infra, I'll point out, my lord, how the High Court, my lord, the NCLT is wrong. I'll just show, my lord, 3 pages. My lord, there was a consortium lending. My lord, there was a consortium restructuring plan.
Yes.
That restructuring plan never fructified.
Yes.
That's not my case only. That's an admitted case of JP also. There are 2 companies. My lord, one is JP and one is JCCL.
Today, it's only an interim order staying the constitution of the COC.
The difficulty is this, my lord. The COC, the NCLT says 2 reasons. A, that part of the restructuring plan is fructified.
Right.
No, despite their admission repeatedly, annually, that it has not fructified, which I wanted to show. And second, that insolvency admission of JAL is pending. Correct, my lord?
Yes.
Now, please, my lord, grant me indulgence, my lord. Page 754. My lord, there is an RBI directive that there is no restructuring possible. You go for insolvency. My lord, 754. Please have a look at, my lord, only one para. 753. My lord, this is addressed to ICICI, who is the lead banker in the consortium. I am one of them, my lord.
Yes.
My lord, para 4 at page 754. In view of the above, your lordship gets, my lord. PDF 815, my lord. My apologies. 815, my lord. Para 4.
Yes.
Lord, para 4. In view of the above, the subsequent steps taken by the bank in pursuance to same restructuring, which was found not to have been implemented before the deadline, cannot be taken cognizance of. The statement that the company is meeting debt obligations as per restructured terms with nil arrears as on date to all the lenders is misleading. RBI is scolding the ICICI bank.
Mr. Solicitor, this order of the NCLT of 13th August issues notice and lists the appeal on 17th September.
Lord, give me a minute more.
But when is the matter coming up before the NCLT now?
It's coming up on Monday, my lord.
On Monday.
But with this.
After notice.
Yes, after notice.
So we will request the NCLT.
No, kindly, my lord. I am really, my lord. I feel it should not have been done, my lord.
But
give me 5 more minutes.
What we will do is we will keep all questions of law open instead of, because ultimately you may succeed in their challenge. You are the respondent to the appeal.
Lord, please kindly, my lord, appreciate the difficulty. My lord, constitution of COC would mean the resolution professional continues, which means nothing. What we could have done.
The thing was that this order was passed on 13th August. Now we are almost end of October. This matter is coming up on Monday. You can argue it before the NCLT.
My lord, can your lordships, for my satisfaction, see 3 pages?
Yes. Okay.
And my lord, 2 paragraphs of the finding. If your lordship feels, my lord, that this is absolutely wrong finding going to the root of the issue.
Yes.
My lord, this is what, my lord, the RBI, your lordship may take it from me. RBI directs that forget restructuring. In 2018, you proceed with the resolution process. Now your lordships may kindly come to 754. My lord, it would be PDF 805, my lord. PDF page 866.
755, right?
Yes.
No. Well, Annexure 812.
866.
866, my lord.
Annexure?
813.
813, my lord. 813. Well, there is something, my lord, real inherently wrong. Therefore, my lord, I am little, my lord, troubling your lordships. Please see the subject matter. What my lord, page, your lordships have, my lord, the letter dated 27th May 22.
Yes.
Please see, my lord, the subject. It's both the companies. My lord, JAL is the holding company, JCCL is the subsidiary. Letter of acknowledgement of debt for Jayaprakash Associates Limited and JP Cement Corporation Limited. Then, my lord, unnumbered para 2, my lord,
Yes.
my lord Justice Pardiwala. It may be noted that while we fully acknowledge our indebtedness in below mentioned outstanding amount, they acknowledge the debt. But what is relevant is page, my lord, 808, which is, my lord, 869,
Yes.
PDF 869. Regarding, kindly mind, and then I'll read, my lord, 2 paragraphs of the impugn order.
Mr.
Mas-
Come to para 17
of this one.
of the impugned order and make us understand what is the sanction letter of 20th June 2017 issued by the SBI
Yes, my lord.
acknowledging the transfer of debt. This seems to be the heart of the order.
Your lordships are right. My lord, but before that, would your lordship see para 12 also?
Is this finding incorrect? On
It isn't. That's where I am leading. My lord, therefore, I am requesting your lordships to come to, my lord, page 869, and thereafter I'll come to that very para. My lord. I was to come to that very para. My lord,
What we will do is, we will say that since the matter is coming up on Monday, and they will decide it uninfluenced by these observations, we will say.
No, my lord, what I am suggesting is this, my lord. What is stayed is constitution of COC. Correct, my lord?
But suppose the appeal is dismissed on Monday, then that order comes to an end.
It is impossible for the simple reason that it is now tagged with JAL appeal.
Oh.
This is JCCL. And, my lord, kindly see, my lord, that is what the height is. My lord, page 40, para 18, my lord. Para 18, my lord, and this, my lord, JP is a quite a intelligent litigator. It would continue litigating. My lord, para 18 of the impugned judgment order, your lordships would find, in the facts of the present case where insolvency against the holding company has already commenced by order dated so-and-so, which is under challenge in so-and-so, which is under consideration, and another order dated.
Is that part of the debt, bucket 1 has been paid off.
That is
part of the bucket has been transferred to the holding company, and there's a restructuring going on in respect to the holding company.
That's your lordships that impression to be removed. Therefore, I am.
But then what? But show us the document where which
I was on that document, Manoj.
Page 866.
808. Well, that is 869.
Let's see that.
After acknowledging that, Manoj, this is later dated May 20. May 20. Correct, Manoj?
Right.
Kindly come to Master Restructuring Agreement. It starts with that.
Read that. Read that.
Master Restructuring Agreement for sustainable debt has been executed by all lenders on 31/10/2017, including State Bank of India with a deed of accession to MRA dated so-and-so. The completion of other legal formalities, including statutory approval on the scheme of arrangement between JAL and JP Infrastructure Development Limited, part of overall DR under process. The implementation of overall DRP, that is debt restructuring plan, is yet to be effected by some lenders, including State Bank of India, that is me, in their respective books of accounts due to non-completion of security creation on MRA, that is Master Restructuring Agreement, security, and pending approval of JAL, JIDL scheme of management by NCLT. Hence, the above outstanding balance is based on the restructured facilities. So they admit that master restructuring agreement has not come into effect. This is 20. Thereafter, your lordship would have the next page, my lord, that is for 21. The same my lord, position continues. They acknowledge the debt of the full amount and say that still MRA is not effective. Well, that your lordship would find at page.
Where do they say that MRA is not effective? They say the implementation of overall DRP is yet to be effected by some lenders, including SBI, in their respective books of accounts.
Yes, my lord. Due to non-completion of security creation on MRA security, they have not given even security. As per, my lord, the MRA. Security and pending approval of JAL, JIDL scheme of arrangement. My lord, they have to, that is rejected now, my lord, by NCLT. My lord, same for next year, which is at page, my lord, 869 for the year 2021. They acknowledge the debt and they say that the same. I have read, my lord, but they repeat it in 2021. Same for 2022, which your lordships would find at page 882, PDF 882. Lord, kindly see 821, my lord, 882, the second unnumbered para. Same thing, my lord, they mention. Well, what? I have a suggestion. I'm sorry. I have a suggestion, my lord. What is stayed is COC constitution, meaning thereby the IRP continues. If IRP joined hand with the builders, my lord, JP is a known builder, my lord, and quite a litigator. My lord, then nothing, my lord, can be done. My lord, what your lordships can consider is let the COC be constituted. My lord, we have to issue RFP, RP, we will have to receive plans, we will not finalize anything. Let the COC be in place at least, my lord. Continuing.
Solicitor will not interfere. We will say that following the impugned order of the NCLAT, dated 13 August 2024, stays
this is Pardiwala's
stays the order of the NCLAT.
Actually incorrect.
And while maintaining the continuance of the IRP, restrains the COC from taking charge. Full stop. The appeal is now coming up for hearing on Monday. In that view of the matter, we are not, and only in that view of the matter, we are not exercising the appellate jurisdiction against an interlocutory order. However, the appeal, any further orders in the appeal shall be passed without having regard to the findings in the impugned order, which are confined, which are purely of an interlocutory nature. Full stop. We would request the NCLAT dispose of the appeal expeditiously.
Would your lordships consider in the event of, my lord, appeal not being heard on Monday,
in the event that
NCLAT may consider modifying the interim,
that the appeal cannot be taken out expeditiously on the next date of hearing for reasons bearing on the exigencies of the work, we leave it open to the appellant to move and to seek a modification of the interlocutory order.
Please.
Item 9, SLP against the same judgment was dismissed by us.
Seeking short pass over.
SLP was dismissed.
SLP against the same judgment has been dismissed.
Yes.
On 24th September 24.
Yes,
And
and 14,000.
Praying for another item 23. Difference is there.
Mr. Diwan, we've already dismissed an SLP against.
But that was, I'm instructed. That was at the on the basis that that particular person who came up was not a party writ petitioner and they were interveners. That was specifically raised. And your lordship is supposed to have made, I don't know, I wasn't there, but your lordship observed that told them that, look, you can file your writ petition, but don't trouble us over here as interveners. These are parties who were indeed writ petitioners before the High Court. So therefore, there's no question about that ground taking it. Now, please, may I just place the issue over here? I'll just indicate as to why we are here. The essential point, there are 2 or 3 points which we want to make. The first point is that the Department of the Commission hasn't followed its own rules. So I will be taking you to the rules and I'll explain as to why they did not and how they didn't follow the rules. So why they didn't follow the rules. Now, we are aspirants insofar as this particular assistant teacher position is concerned. We are hopeful that we should have been, had the rules been correctly applied, we would have been considered for the purposes of probably for the interview and for the purposes of consideration. Now, I'll just broadly tell your lordships what has happened over here. There are 2, 3 points. Would your lordship please take up the rules first, and your lordship will find those. Go directly to page annexure P1. It's at page 349. May I state the point?
Yes.
So there are 3 points essentially. The first point, I'll just state the points and then I'll take you to the rule. Point number 1 is that they are obliged under Rule 83B to project the number of vacancies. It's an obligation under the rule itself. And this has to be done on the date of publication of the examination or interview. It's our understanding, keep those documents with you. It's our understanding that they fell short according to their own documents by at least 5,000. So they should have, because there was a gap in that particular period, which I will explain to you, there was at least 5,000 additional seats which should have been shown. Sorry?
Elections of 2019.
Yeah, but it is now, the injunction was operating. The injunction was operating till it was vacated.
Recollect, my lord, we had submitted that for the first time, my lord, the 2016 batch, my lord, is being cleared by the High Court. From 16 till now, my lord, it has been stuck in, mired in litigation. And, my lord, persons who, my lord, who are unsuccessful are now, my lord, saying that if you had published an advertisement in this fashion, then I would have...
You have to follow your rules. It's simple. It's simple. You must follow your rules. So I'll just go step by step. And there was an injunction operating in my...
5,000 more vacancies should have been advertised.
Yes. So that's, I'll just state the point first. So that's one part which we say and which has not been appropriately and accurately, at least 5,000. It may have been more. My second respectful submission is going to be that insofar as migration is concerned into the general category on merit, because if obviously if you're a general category, if you're a reserve category candidate, but you are meritorious, you would be entitled to migrate into the general category. That was done contrary to their rules. Now I'll just state why it was done contrary to the rules. The rules contemplate that there is a 10 mark, which is amount a mark which is to be given for the purposes of what is described over here as a personality test. So this, without that personality test being conducted, they allowed the migration, thereby reducing the number of seats which would have been available had they had the migration been done after the viva voce or whatever, the personality test.
Point?
Yeah, the third is that the rules itself require that the ratio in which they have to call for final vacancies is for the interview is 1:1.4, which has been violated. Now this is black letter law in the sense it's in their rules itself, and that's why all my submissions are based on their rules. So these are the 3 broad points which we want to canvass. Now would you please go straight away to P1? So I'll just place that rule. There's just 2 rules or 2.5 rules.
2016 selection, we've already dismissed one SLP now. I think let's put a closure to this.
But then how there was an injunction which was operating before the division bench right through?
I think, this litigation on matters relating to recruitment of assistant teachers, at some point of time, we must also look at the broader public.
May I just tell you who I am? I am an aspirant. I am not for a moment saying. Now, if you are an aspirant, and if they don't follow their own rules with regard to how to compute merit, how many people are with regard to vacancies, etc., then where is the question, Manoj? You follow your own rules. That's all I'm saying. That's my request.
We have already considered these very submissions in the earlier petition, and we rejected the petition. We must follow our own order. Thank you, Mr. Diwangi.
Very well.
In 23 law, in 23 law, the same points, but additional one aspect. Same. That train can...
Court holds that, look, applying NICMA's recommendations would amount to virtually rewriting the contract.
That's item 10, Milord. I appear in item 10.
Sorry.
Then
my girlfriend was mentioning item 23.
23 is connected, no? We are dismissing. We'll follow the same in 20.
Right. Only one aspect I mentioned. I'll leave.
Then wait for 23 to be called out.
Right.
Then.
Yes. But I'll satisfy my lord that there is no question of the arbitral tribunal rewriting the contract, but there's not one antecedent point as well. Your lordships have held, my lord, repeatedly that the duty of the Section 37 court is to examine whether the Section 34 court has erred in exercising its jurisdiction.
But you know, the arbitrator,
yes,
it says that wrongly assumed that the municipal commissioner accepted NICMA's recommendation to revise the escalation formula.
That's directly there in the municipal commissioner's letter of 19th of February. I'll show that.
Labour factor to 0.9 and the material factor to 1.20.
Yes, that is directly there, my lord, in the in the municipal commissioner's letter, 410, page 4.
How much was this price escalation claim?
I'm sorry, my lord?
How much was the price escalation?
No, the price escalation claim by me was approximately 1.5 crores. 1 crore awarded by the arbitrator. 1 crore awarded by the arbitrator. The Surat municipality had accepted about 50 lakhs as its liability. On this letter, my lord, kindly see. But my lord, I make one more legal submission, my lord. The Section 37 court, if your lordship sees their entire reasoning from paragraph 41, at no point do they analyze the Section 34 order. Your lordships have said, my lord, in repeated judgments that the duty of the Section 37 court is to examine whether the Section 34 court has erred in exercising its jurisdiction. My lord, I've tendered those judgments, my lord. Would your lordship just see kindly Punjab State Civil Supplies? My lord, I've tendered the judgments. I think your lordships have it, my lord.
Yes.
Would your lordship kindly have that decision, my lord? That's a very recent September 2024 decision. Does my lord have it?
Yes.
Para 20, my lord. Para 20.
Yes.
But I'll satisfy my lord even on the rewriting. In view of the above position in law on the subject, the scope of intervention of the court and arbitral tribunals is virtually prohibited, if not absolutely barred, and that the interference is confined only to the extent envisaged under 34 of the Act. The appellate power of Section 37 of the Act is limited within the domain of Section 34. It is exercisable only to find out if the court exercising power under 34 of the Act has acted within its limits as prescribed thereunder, or has exceeded or failed to exercise the power so conferred. Now kindly, my lord, have the impugned judgment. The discussion starts at paragraph 41.
Yes.
And your lordships may take it from me, my lord, from paragraph 41 till paragraph 50, my lord. There is not a whisper about what the Section 34 court has done. There is directly, my lord, in fact, a fact-finding of the dispute itself. There is no application of mine to, my lord, the Section 34 parameters.
Well, let's just hear Mr. Mehta for a moment.
And
Mr. Mehta, what do you have to say on this?
Lord, would your lordships just see page 473, my lord. The arbitrator himself says that I'm rewriting the agreement.
Where is that?
He's himself saying it.
What PDF page would that be?
Lord, PDF page would be 72 of the second volume, my lord.
My friend, give me the page number, I'll give the PDF. My lord.
Yes, if you can just give.
473 is the page number.
No, that will be PDF 502.
Lord, para 7.7 of the award.
This printed page 480?
473, my lord.
All right.
Lord, there is already an escalation formula. They wanted that some other formula should be adopted. There is a formula already in the agreement. The learned arbitrator says that I can rewrite it.
Where does
Please
it
see,
say
my
that?
lord, 7.7, para 7.7. Your lordship have it?
7.7. Yes.
Page 473. Therefore, it appears that the claimant requested that the recommendations of NICMAR be applied to modify the formula stated in the contract agreement. And the officers of SMC did consider sympathetically the seized claimant's demand in that background. The formula gives him 30% escalation. We agreed to take it to 40. He wants 55. So, my lord, he said that the formula should be changed so that I get 55. Please read further, my lord. There was nothing wrong in that approach. In the background of what has been stated above, taking recourse to NICMAR recommendations to modify the contract escalation formula cannot be considered unreasonable. The claimant has done so. It is correct that the SSNL had agreed with recommendation of NICMAR in order to give incentive to the contractors to complete the works in time, and therefore an MOU had also been prescribed. If the corporation officers did not do so, they must be having their work-specific reasons. MOU was not a must for making use of recommendation of NICMAR to modify the contract escalation formula. So, my lord, NICMAR was a recommendation for another project, which was Sardar Sarovar project. We have a contract of our own in which there is an escalation clause 35. The arbitrator says, I can rewrite it. The learned district judge says nothing wrong with this, it's very fair. The High Court, my lord, division.
That's why the High Court says that, look,
High Court says you can't rewrite the contract.
Milord, may I show that contract clause?
The judge is right, and the arbitrator proceeds on the basis that he is modifying the price escalation formula.
2 pages.
It's all right.
May I show only
And
2 pages?
page F, page F, my lord, of the synopsis, para 4, they also say the same thing. Their understanding is that the formula has been revised, needs to be revised. Please see para 4 at page F. The Honorable High Court failed to appreciate that the present case was not a dispute whether learned sole arbitrator had gone beyond the terms of the contract, but was instead a question of fact as to the extent to which the price escalation formula was to be revised. The learned sole arbitrator, based on detailed evidence submitted by the parties, revised the price escalation formula after consideration. So they wrote the
you also accept the fact that the arbitrator revised the price escalation.
Milord, with respect, Milord, kindly have the clause, Milord, because the clause is not applicable. Kindly have the clause, Milord. I'll just show your lordship 2 pages and rest.
If the clause is not applicable, then how do you claim price?
Milord, because the clause
I
is
gave
not,
1.95 crores is paid. 1.95 crores is already paid. Another 51 lakhs we have agreed. He wants, my lord, even more than that. So I have paid him 1.95 crores.
Milord, your lordship, give me 1 minute. Your lordship, give me 1 minute. Milord, kindly see, Milord. This is a claim arising. Milord, kindly give me 1 minute, Milord, just to show 1 page.
Okay, we've now seen the matter. Thank you.
This is well after, Milord, the contract.
No, thank you. Item 13 and 22.
I'm obliged.
Item 13.
Malak sir, please issue notice in the connected matter. Yes, my lord.
In 13, say identical point.
Same judgment, common judgment.
All right.
The Sena matter, Ravi Kumar.
Notice.
Malak sir, fix it in the 2nd week of November.
All right.
12 November date is showing.
This is also along with 15.
It's an interim order constituting a committee by the High Court.
Lordships, we have a difficulty in that because the neutrality has been completely given a go by, which was what the single judge had done. If your lordships just sees the single judge in 2 batches, there were 2 batches, your lordships, of 2014 TET and
now the committee will consist of 1 member from the University of Kolkata.
Your lordship,
Then,
don't have any objection except that the board's representative and Calcutta University, because Calcutta University was board's nominee.
And ultimately, this is going to come back. The correctness of the report will come back to the High Court.
Therefore, let there be a neutral committee. Let the either Jadavpur or Vishbharti. We don't have any difficulty with that. It has to be a neutral body, not a body which has set the question papers, which has made the wrong answer keys.
So now the committee consists of representatives,
yes,
3 members.
Yes.
1 member from the
University of Calcutta.
You say Education Board of the state government.
Primary education.
Primary Education Board and Vishwabharati University to direct one member.
Yes.
And University of Calcutta. You have no problem with Vishwabharati and Calcutta.
The board is the interested party.
There has to be one person from the exam the board which has set the exam.
Exactly.
So otherwise, this is not that kind of a situation where, without reference to the examiner,
there are 2, even according to you, there are 2 members on whom you have no difficulty.
Your lordships, only 1.
Only 1.
Only 1.
Why?
Only the university member, to which we don't have a problem. We have a
what about Vishwabharati?
Yes, your lordships. We have a problem both with University of Calcutta and nominee of the board.
Why do you have a problem with the University
because
of Calcutta?
University of Calcutta is the authority which had acted at the behest of the the opinion, the previous opinion was given by the university.
It's on record in my SLP.
Well, is it not possible? I mean, just to have, to give to give them a sense of confidence.
Yes.
That, instead of having the University of Calcutta, Vishwabharati can be there, and one more independent person.
Milord, as far as the board is concerned, Milord, it's just a committee, Milord.
The board has filed an affidavit in the High Court in response to an earlier order saying that what we have done is perfectly right. Our committee has examined it and we have worked very hard. There is no error. Then the High Court refers it to the University of Calcutta. The University of Calcutta comprises a committee of 3 experts. That committee has again filed an affidavit before the High Court saying the questions are all okay, the answers are right, there is nothing wrong. Now our problem is if out of the three, two are those two whose affidavits are already on the record.
But therefore, we can do this. What you are suggesting is have somebody from the Vishwabharati, somebody from Jadavpur.
Yes, Your Lordships.
All right.
And then one.
Let the board should be present.
Lordships, the board cannot be the.
Let, this is not that kind of a situation.
What we can do is that we can say that the, should we say that, subject to, I'll just talk to my brothers, that the secretary of the primary education board will be an ex officio member of the committee.
Correct.
To assist the other two members. Are you willing to do that?
That can be done. As long as he is not giving an expert opinion on the answers.
Calcutta University is a very large body. I mean, why would this? What we can do is
The other persons.
that the same member who had given the opinion on behalf of Calcutta University earlier will not be a part of the committee.
What single judge has done.
These are academic questions. This is not, my lord, as if there's a fact-finding mission going on.
What the
In which, my lord, adjudication will take place.
Can be restored.
What is the order of the single judge?
The learned single judge said,
Jadavpur.
Refers it to the Jadavpur.
for the aforesaid purpose, that is.
Single judge referring to the VC of Jadavpur University.
Correct. To furnish to the Vice Chancellor their documents, let the Vice Chancellor submit a report through to the registrar within a period of 1 month.
The point is there were 24 questions.
23 years.
23. Issue is whether the answers were wrongly framed.
Correct.
This is really, I mean, what's the big deal about this? There's no issue of bias here.
It's a job, it's the life of every candidate. Your Lordship.
These are academic issues, my lord.
What is neutrality?
Ultimately, it's an academic issue.
It's a
The examining body must have somebody there.
We interfere at this stage.
Your Lordship, only what
Your
Lordship
Lordship may-
is suggesting is perfectly acceptable. I think even
Your Lordship may do one thing, my lord. The University of Calcutta, Your Lordship may substitute by the other university, and then that can remain. And the other thing which the division bench of the High Court has done, it has shut us out from filing any representation or any of our.
They're referring to an academic expert.
Yes.
Trial.
So the other person will be Vishwabharati, right?
Yes. So instead of Calcutta, Your Lordship may make it Vishwabharati. Let the board be there.
So Vishwabharati is already there.
Jadavpur. Your Lordship, instead of Calcutta, Your Lordship may make it Jadavpur.
Whatever, Miller, I leave it to your lordship.
Then the board
This is
is
just a
there,
committee
Jadavpur is
which
there.
will decide whether an answer to a question is.
These candidates, it's a last chance for these candidates.
Well, this is not a political dispute.
Whether they have get anything.
Yes.
Thank you. That's me.
Lordship, the board is also amenable. Lordship,
And now item 16, who is appearing?
Only then one thing. The learned single judge allowed us to give our representation. Please allow us just.
But this is an academic issue.
An academic issue. Let them
There can't be a trial on this. Miller.
Yes.
Can there be a time frame for that if they decided after a
36.
long time?
Item not at all. Item 16.
Miller, 36 and 38 may be, Miller, connected. Miller.
Yes. All three matters.
Yes.
Item 16.
16.
Then would we withdraw it?
Already can withdraw it.
So that then we can
dismiss as withdrawn.
Very good.
Yes,
Item 16.
Anyway, it's an interim order. They can go to the
Item 16, yes, Your Lord.
Go to the High Court. Why have you come under Article 30?
Your Lordship, the glaring violation of right.
The High Court under Article 30.
Your Lordships are already looking in
We are
another
ready to
matter.
move the High Court under Article 226 of the Constitution. The petition is accordingly dismissed with the grant of liberty in the above terms.
Your Lordships are transferring it. Transfer it is a very. We are here dealing with the children of studying in the government schools, Your Lordship. And
remove the High
see
Court.
the glaring.
Item 17.
Government has not created.
Item 17, please.
Yes.
Government has not created even a post of chokidar.
I am in
Oh, sorry,
17.
sweeper.
Yes, item 17.
Kindly take this, just a note of one chart I want to show what is happening in this process of IBC.
I am the petitioner. Kindly take.
The plan is fully
Someone is-
implemented. We
we are
have paid,
too old.
bankers have got, it's all done.
We have implemented. We are too old for this.
And he has
When
taken
IBC
back
matter comes, you preempt the
1 year
petition by saying plan is implemented, don't hear the illegality. That's what's happening.
Yes.
1 month ago, the matter is decided, 1 month everything is implemented, don't hear the matter. That is kindly
1 month
turn-
is a lot of time when it comes to bankruptcy.
That's not an excuse for preemption, Mr. Salve. Now let's kindly turn to the table at Big Roman 4 and see what is happening here, what people are trying to avoid. Page 4 of the note.
Hand it over, then it may be
Give a
shared with
copy.
us.
Please give it to them. Why don't you give a copy to them? Well, it's Big Roman 4 table. Roshu's got it?
Yes.
I am Torrent. The other side is Sharda. Roshu's got that?
Yes.
And the person who was actually H1 was Vantage. This is at the conclusion of the negotiation process.
Right.
Now he is 1408, Torrent is 1790, and Sarda is 1553 with 240. I hope I'm clear, Malus?
Yes.
240 is deferred. Upfront is only 1553. After knowing H1 and only involving Sharda unilaterally, that 250 is added on to the upfront, made into 1793 at the bottom. Not sure you got that?
Yes.
After the negotiation process has ended, and after Sharda knows Vantage's figure, which has been declared H1. Now, with those facts, kindly come to the top of that note, para 1. I'll just read 5 small sub-paras. How was it done? The only difference is that this 240 is a net present value. So net present value, you can do changes ex parte surreptitiously behind the back of the other bidders after the negotiation date. And he turned to para 1.
What the NCLAT says is that R2's draft resolution plan indicated that it would make a deferred payment of 301 crores.
Yes.
And the NPV of this sum is rupees 240.
40, correct. That's right. That he put in the deferred column.
And the resolution plan itself permitted the COC to opt for either deferred.
That's
or
wrong.
unpaid.
That's right.
Yes, indeed.
Come to para 1. Para 1.
One of
the note, I'm sorry. At the page 3. Page 3.
Right.
I'll just read 4 paras of this for a sub-para. See, Manoj's Torrent submission. I'm Torrent.
Yes.
Sarda's Appendix 1 clearly shows that it has offered only a deferred payment of 143 and 158 at the end of second. There was no option of upfront payment of 240 in Appendix 1. That's how you bid. In any event, an option could never have been provided because Appendix did not provide or contemplate providing such options. Applicants were allowed to enter either upfront or deferred payment in Appendix 1 and could not change from deferred to upfront or vice versa, irrespective of whether NPV changed or not. Next, just 2 more paras.
So this was
Sharda
a modified offer after the negotiation was completed.
No. Again
H1.
wrong.
And in the first round, the NCLAT, the matter went back to NCLT. We won in the NCLT first. From the NCLT, it came to NCLAT, they won into the remand. So it's the second time.
And then an equal opportunity was not given to all bidders.
To all. And
No.
Now, Sharda consciously chose to offer deferred amount in Appendix 1. That I'm reading, para D. This is important. Despite being aware of COC's expectation of upfront payment mentioned in the RP's email, just put a page there, 173.
Are you willing to match? Suppose we issue notice. Are you willing
to match? I'll give an undertaking here. I will exceed by 10 rupees, whatever is the thing. And I must give that undertaking. Give me just 2 minutes more. Just see the next 2 paras.
Yes.
This requires notice and consideration is my point, Billis. Once the
Complete
negotiation...
litany of wrong statements.
Allow me to finish, Mr.
Finish all your wrong
statements. Once the negotiation process concluded on 19th April, the commercial offer given by way of appendix stood frozen. Thereafter, no change was permissible. Now, look at this, fellas. As per step 6 of the annexure to the process note, that is page 234.
Notice,
That's
one. May I just read one para of the NCLAT? 4 wrong statements have been
1
made.
month ago. Well, implementation in 1 month.
1 month or
is
not 1 minute ago also the order is right.
Your Lordship should not allow further implementation. Call it after the
No.
Diwali
Let me read one para at least.
And even
that's the justice of the
4 wrong statements have been made.
We'll issue notice.
But even while the appeal was pending, the appellate tribunal was pleased to clarify that anything done would be subject to the result of the appeal.
That's
the minimum.
Any further steps which are taken thereafter until the appeal is taken up for hearing shall not create any equity. The submission which has been urged on behalf of the appellants by Dr. A. Abhishek Manu Singh, Learned Senior Counsel, is that the bid which was submitted by bid which was submitted by Sarda Energy and Mineral Limited, the successful resolution applicant was modified in material respects after
negotiation.
After the conclusion of the negotiation process.
Yes, sir.
Issue
Lord,
notice.
please note, we say this is wrong.
Just note.
We say this is wrong.
We will say that any issue notice, the appearance is legit. The counter affidavit be filed within a period of 2 weeks. List on any further steps which are taken in implementation of the resolution plan by the second respondent shall not create any equities in their case.
Would your lordship just record one submission of the COT that the entire money has been paid and disbursed? That may also come on record, so that
You can put that in your
because your lordships have
We'll do
recorded
that.
the statement of all the steps.
hereafter we have said.
Not all
That's
steps.
all right.
It's complete.
Therefore we have said hereafter.
But your lordship just
Whatever you've done.
only for the matter of
Oh,
records.
that's all right. All right. Sorry.
Completeness.
You say that in your affidavit.
Lord, kindly just clarify that.
We'll have to be satisfied that all thing has been done. Will you say that in your affidavit? Yes, item 18.
That's all right.
Item 18. All right, there's much more than meets the eye in this matter, sir. That's why we issued notice. We have seen through it. Yes, item 18.
Mr. Rothi is leading me in this matter.
Sorry?
Mr. Rothi is leading me in this matter. If my lord may kindly pass it over.
The project was allocated to another party on 5th of December.
Lord, there's a. May I just make one point for my lord's humble?
5th of December 23, the project has
They
been
haven't
allocated.
disclosed it, but there's a further point. Lord, there's an amnesty scheme. Everyone is eligible. I am also eligible.
And ultimately, it's a hydropower project. It's an interim order. Why should we stall the?
No,
It's a
not
hydropower project. Any interim orders by this court, look at the cost escalation. Will not issue any such.
Bear with me for a minute. Bear with me for a minute.
Will not interfere.
Kindly bear with me at least for a minute. Let me make the point.
Thank
My
you.
lord,
Come in a better
amnesty-
matter.
my lord,
Sorry,
amnesty
item 19.
was brought in to ensure.
We have to only look at the dates, in these kind of matters. It's a robust common sense.
All right, then only one request.
Yes.
One request. Lord, the matter is apparently coming in December. Your lordship may say they'll consider and dispose it off on that day.
Let the High Court do it. I mean,
My
we're
lord,
not
it's
here
not-
to, we're not some supervising engineers over High Court judges.
Lord, we are only requesting a little nudge from your lordship to say that
Not in these matters. It moves the High Court, yes.
Lord, the High Court has for 1 year
The
just
matters as
kept
well.
the matter pending, and the other side did not disclose the fact it was allotted, my lord.
When such a request is made, I always wonder how I would have felt if I was in the High Court and I got this order. The High Court judges are really busy. So he is dealing with anticipatory bail and service and pension. And
Can I put it the other way? My lordship may record my submission that they may entitled to make a request.
all right, you can move that. Yes, chalo. Nice. Thank you. 19.
Please say one thing, Lord. It's listed in December. Lordship may make an observation at the heard.
Sorry, you move the High Court. Thank you.
Lord,
19.
we are struggling for 20 years, Lord.
All right, 19.
From 2003, Lord.
All right, 19. To be tagged with, this is to be tagged with repetition civil P11, no?
My lords, both 19 and 19.1, Annexure P1.
To be noticed and to be tagged with the other matter.
And also, my lords, the state protection that we have got with.
Is there a protection in that matter?
My lords, 19, Annexure P1.
But if there's already a protection in one matter, why do we have to do it here?
Very well. And my lords, constitutional bench judgment may
Notice and
also clarify that. Grateful, my lords.
Can I make a request?
Yes.
I'll withdraw it with liberty to move the High Court for expeditious hearing.
Mr.
Better
then it's in account. States that
Looks better,
the
not
petitioner
like
would
back to
wish
the
to
High
withdraw,
Court
wish to withdraw the special petition, since the petitioner intends to move the High Court for expeditious
very good.
disposal.
Very good.
The special petition is dismissed as
very good.
Well, it's item 20. Sorry. Well, it's please, my lord, because last time I'd handed over a deed of settlement pursuant to which they were supposed to pay us $75,000. My learned friend sought time to take instructions in this, my lord.
Lordship, we tried to connect with the client, but could unable to connect. And we know.
So then we'll have to appoint an arbitrator.
Yes.
We'll have to appoint an arbitrator then.
It's a tribunal of three, but if only sole arbitrator can be appointed.
We'll appoint a sole arbitrator. How much is the claim, you say?
Plus, the total claim was $234,307.
$234,000.
Out of which 50,000 they have paid, so I must acknowledge that much.
They have paid 50,000.
Yes, pursuant to this deed of settlement.
All right. Ms. Vanshija Shukla was appearing in this in a previous matter. We'll appoint Ms. Vanshija Shukla as the sole arbitrator.
Obliged.
Just tell Vanshija we have appointed as our sole arbitrator.
Mr. Surendranath is appearing in this 23, my lord. Can
26,
23.
Same just tag.
But
Now we'll follow the same order.
read petitioners, they are not intervener.
That's all right. We'll pass the same order. 26.
Not on this individual, but there are two difficulties now.
Ms. Vanshija, we have appointed you as a sole arbitrator in one previous matter. Please do it for this. Yes.
Grateful, my lords.
Lord, we are not on the recovery from this particular person. I'm not on the state. But there are two difficulties in the order, my lord. What it has done, one,
I make recoveries from an officer
No,
now.
no, I'm not-
The junior
no,
informal.
I'm
We'll
saying-
then keep the question of law open.
yes, my lord. But there is one point, if my lord may I.
How much was the amount here?
My lord, I'm not on this in this
Flag.
flag. I'm not, my lord. I'm not. But what difficulty has happened? The why I'm saying. What has happened that he was appointed on this post and this qualification was essential. Now High Court says it is not. High Court says that if you are appointed in a below post and you are promoted to a higher post and you acquire that qualification which is necessary for that post, then also you have to pay that's the difficulty of the state. I'm not saying.
In regard the effective consequence of the impugned order of the High Court would be to restrain the state government from making recoveries of an amount approximately of rupees
6 lakh.
6 lakh paid towards advance increments. To stop bearing in mind the facts and the quantum, they're not inclined to exercise the jurisdiction under Article 136 of the Constitution. However, we specifically clarify the question of law is kept open to be adjudicated in an appropriate case.
Deeply.
Especially petitioners. Item 28. You are appearing for the petitioner?
No, but for the respondent.
For the respondent. Who's appearing for the petitioner?
I seek for a pass or my lord
All right,
the
just
Mr. Call has
pass it over. 29.
Your lordships may pass it over. Mr.
All-
Call is
all
leaving.
30.
Lordship, I seek for a short passover. We are led by the learned SG in this matter.
29 lordships can't hear, I know, but otherwise we are ready and we are keen to go on. But
Let's see, let them, we'll keep it on the reopening, yes.
that's the only issue.
On item 30,
29, my lords, is keeping on the reopening.
no, we've just passed it over. Let him
Pass.
whoever is coming come.
Yes.
The Lordship, in item 30, we seek for a short passover. We are led by the SG and he is
31.
My lordship's interim order has been complied with.
Your lordship.
We have been allowed to register and consequently will be taking the exam.
Your lordship, we've
Further directions are required now. We'll just stand it over.
please, your lordship, because we have the rules ready.
We had allowed these students who are in the final year of the law to appear for the All India Bar examination.
Already covered, your lordship, this AIBE exam. For the next exam, the rules are ready. We just need to put them to the stakeholders. Your lordships have it after 4 weeks. We should be able to submit them.
Right. The interim order dated. That was passed in this Nilai case.
Yes.
Your lordship.
20 September 2024 has been complied with, and the petitioners and similarly placed candidates have been permitted to candidates who are pursuing their final year of the LLB degree course, right?
Yes, ma'am.
Have been permitted to be registered for the All India Bar examination scheduled to be held in the month of
25th November, your lordship.
25 November 2024. Full stop. Learned Counsel appearing on behalf of the Bar Council of India states that the rules in the meantime have been prepared and are in the process of stakeholder consultation.
Please, your lordship.
The then should we dispose it off now?
Lordship may have it after 4 weeks. We'll place it before your lordships because then otherwise the interim order will.
List on kar do after 4 weeks.
I'm highly obliged, your lordship.
Obliged.
Your lordship may give us short passover. Senior counsel is coming the way.
33.
I'm requesting for short passover. So 33.
Who is appearing in 33?
Mr. Gonzalez is appearing. Mr. Gonzalez is appearing. I'm sorry.
Okay.
Sir has filed a.
Let's make the Passovers then. 39.
30 and 39 are to be heard together. So we'll seek a short passover in both.
This one. We'll keep it on the reopening.
29 passover.
28 Monday for Ramdo. 29.
Your lordships may recall this is the international.
Yes.
Oh, 29. I'm sorry.
Your lordships may recall this is the International Arbitration Award, which has been upheld by the Section 34, set aside by the 37.
You can start the matter then.
Your lordships may take. Mr. Kaul is leading me in the matter, your lordships.
For the petitioners?
Yeah, we are for the petitioners.
Mr. Kaul is for the petitioners and Dr. Singhvi is for the respondents. Points. Okay. 30.
On a non-miscellaneous day, your lordships.
Keep it on Monday. And we start for 10 minutes. You can keep it on the following Tuesday then. 30.
30 and 39, Milord, I think the learned solicitor.
I refuse for respond number 1 is right.
This is, Milord, that award against IRB made an offer for the court.
Yes.
The learned solicitor is not available.
32. Anybody here?
Milord, 30, your lordships have kept back.
Yeah, kept
yes.
back. 32.
In item 32, my friend had to file a response, Milord.
You're for the National Medical Commission.
Yes.
This is it's a very interesting case of a candidate who is physically challenged, wants to appear for the apply for admission to the MBBS degree course. Now we got the evaluation done by Dr. Satyendra Singh, who says that with assisted devices that candidate is capable of doing the MBBS. We thought we'll seek your assistance as the medical commission.
Milord, I have taken instructions in the matter. The child is very bright, Milord. The number he scored in the NEET is 610 out of 720.
610.
610.
So if he was not physically challenged, you would get admission where?
Very good college in the country, Milord.
Now, what has happened for this year?
This year, Milord, it is going on. He has time till tomorrow, Milord, because counselling, the process is there, Milord. The only one concern we have one concern.
That we have perused a report. Though the petitioner suffers from a physical disability, we have duly considered the report which has been submitted by Dr. Satyendra Singh in pursuance of the order dated.
In pursuance of order dated 1810.
18 October 2000.
Let me suggest, Milord, it will be. I'm not going against his admission. The only thing I want to say is, Milord, as per the regulation, Milord, the medical board has to be constituted with the specialist of that disability. Like for locomotor disability, the person has to be from orthopedic and neurology has to be there, Milord. We have 2 AIMS report, Milord. Dr. Satyendra Singh is only a physiologist, Milord. I'm not going against the admission, Milord. My concern is the report. So what my suggestion, I'm giving a suggestion, Milord. Let me give a suggestion.
Two reports.
2 tests. Now no further.
No, Milord. I'm not saying for any test.
Give him a chance. Give him a chance.
Milord,
what is your suggestion?
My suggestion is, Milord, in the facts of the matter, the petitioner may be given admission. But this judgment and this process should not be presented as a precedent. This is what I'm trying to say.
Say that.
Because he is not a competent person to give, but we are not against the admission of the student.
All right. We have heard several appearances. The National Medical Commission has fairly stated before this court that bearing in mind that the petitioner is a bright student having scored 610 marks out of a maximum of 728, he may be permitted to participate in the ongoing counseling process, subject to the clarification that the proposed direction of this court should not be treated as a precedent, concluding all issues of law which may arise in the future.
As well
any other case.
As well as the latest report, my lords.
In
Report is the problem is only the report.
right, in any other case.
He scored 601.
601. my lord.
601. Full stop. We accordingly direct that the petitioner be permitted to participate in the ongoing counseling process for the NEET UG 2024. For NEET UG 2000, arising out of NEET UG 2024. Full stop. We clarify that this order is passed in the facts and circumstances of the case of the petitioner and the report which in the case of the petitioner and shall not be construed in the future as the expression of any opinion by this court as a conclusive opinion by this court on any issues of law which may arise in an appropriate case.
No difficulty. Just to update, my lord, we are re-evaluating the entire regulation just to see how to.
Plus, there is a need for actually a complete change in the approach. If I may so, with the highest amount of respect for everybody on the other side.
Anyway, we have granted relief to you.
Over.
Yes.
Matter is over.
Right.
I am obliged.
Leave that. Thank you.
Grateful.
Grateful.
Yes, Lordship, I request. Lordship, I request if it may be taken up after lunch, Your Lordship, because Mr. Gonzalez
It will not be sitting after lunch, so we'll take it up on the
reopening day.
Why don't you give us submissions in?
Your Lordship, I have circulated.
You have circulated the submissions.
Ideally speaking, Malaj, we would also want to bring something on record and affidavit.
When it's a matter relating to issues of accessibility for the physically challenged in public transport.
Malaj, we've seen the report. The reports conclude.
We have referred it to the Nalsa Institute for
CDS.
For disability.
Yes. Malaj, but we've seen the report, but there are one or two observations which I want to make against. Malaj have seen it. In that, there is a conclusion that Rule 15 is contrary to the Act. That's one of the recommendations. According to us, Malaj have seen the Rule 15. It specifies various different standards and guidelines. Those standards and guidelines are, according to us, to be considered.
Give us some submission at least. Put it on give us some written submission at
least. We do that?
When will you file it by? File it by this Monday?
Monday. I need a weekend.
Right.
Your Lordship, what I'm requesting is we have also made our suggestions independently of what Professor Amita Dhanda has made. She has submitted her report and her own suggestions. Petitioners have made their own suggestions. Kindly keep it on reopening day, Lordships. We'll
give it to them to file their submission. We'll keep it on Monday after we reopen. We'll consider it on Monday.
Yes. Yes. And Malaj, that's what our submission is.
Don't ask for time on Monday. It's a very important matter relating to access to public transport to the physically.
But I don't think, I think
we have to do something in these cases.
Malaj, I think.
How do you make our society a good, happy, humane society?
Malaj, no doubt. But according to us,
there will be 25 technical reasons not to do so, but we should find one justifiable reason to do so. That's all.
The report was unnecessarily of the view that it contrary to the rule is contrary to the statute, which it is not.
We hear you on that.
It's not contrary.
Because counseling is going on.
Order out right away, that 30 order.
32 minutes. Grateful.
Your Lordship, the solicitor is at his legs before court.
We have contact.
What is this?
Here for the National Highway matter. Keep it after the reopening.
Grateful.
We'll take it up after.
Monday after reopening?
Monday after reopening.
Grateful, Your Lordship.
And also that review was, I'm sorry, I was on my legs. The review was for that item 28, Manoj, the review where Lordship said gave a brief.
Yes, but you have given a brief submission.
Yes. Would your Lordship want it on Monday?
Take it up. How long will you take roughly?
I can argue now. I have no difficulty.
You are for the respondent.
I'm for the petitioner.
And who's for the respondent?
I'm appearing for the respondent, my lords. So, my lords, in the previous call, my lords said after vacation. Now, we have to inform the councils.
Then what we'll do is we'll keep it. It's a review. We'll take it up first on board so that the review is over and done with on.
May I only request then, as your Lordships have said, first on board on Monday?
Yes, Monday we'll take it up first on board so that then we can dispose.
Yes, can I make one request? There was one error which crept into our written submission, factual error. Can I correct that, my lord? There's only one error. I must say before I start, I must correct that. I've said 2 clauses of the wrong agreement. I have to put on the right clause.
It's on page
copy to Mr. Rawal also?
Yes. I know he's on the same side.
Oh, I see.
And you're on the same side. We'll give them today itself. We'll do it and hand over.
Wishing you all a very happy.
Likewise, very happy.
Likewise, on page 3 in the figure, instead of 38, it should be 34.
Just send a fresh one to the court master.
Today do it.
Court master.
Yeah.
Happy Diwali, my lord.
Thank you. Happy Diwali to everybody in the court.
Great.